So, what is a hostile work environment? I get calls every day from workers who think they're dealing with a hostile work environment, but they're really not. A hostile work environment is more than just hostile coworkers or managers. A hostile work environment is a legal term with a specific legal definition. So, if a hostile work environment is not just hostility at work, then what is it? Well, a hostile work environment is a form of discrimination. And with any form of discrimination, the conduct has to be based on your protected characteristics, like your sex, gender, race, national origin, or disability status, just to name a few. But there's more to it than just that. So let's get into that. Very quickly, nothing in this video is legal advice. But if you want legal advice and you think you were subjected to a hostile work environment in Washington State, feel free to reach out to my firm. The link to my website is in the description below. Remember what I said earlier, a hostile work environment is a form of discrimination. So to understand the law against a hostile work environment, we have to look at the law against discrimination. And the law against discrimination can be found in Title VII of the Civil Rights Act. And most states have their own laws against discrimination too, which are usually broader than Title VII. But those laws usually mirror Title VII pretty closely. So today we'll just be looking at Title VII. And Title VII says the following: "It shall be an unlawful employment practice for an employer to fail or refuse to hire or to discharge any individual or otherwise discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment because of such individual's protected characteristics." Now, the important takeaway from that law is that it prohibits discrimination with respect to an employee's conditions of employment because of the employee's protected characteristics. Now, the most obvious forms of discrimination happen when a company takes some adverse employment action against you because of your protected characteristics, like an employer firing you because of your gender or race. But the employer doesn't need to fire you to break the law. Changing your conditions of employment because of your protected characteristics can also qualify as discrimination. And that's what a hostile work environment is. It's when you endure abuses at work based on your protected characteristics, and the abuses are so severe or pervasive that they change the conditions of your employment. That's what a hostile work environment is. But to be considered illegal, the hostile work environment has to meet certain criteria under the law. So let's go over those criteria now. So what are those criteria for a hostile work environment? I'll put them up here. First, there must be language or conduct concerning your protected characteristics, or that only occur because of your protected characteristics. Second, the language or conduct must be unwelcome. And third, the language or conduct must be so severe or pervasive that it alters the conditions of your employment. Remember back to Title VII, it has to alter the conditions of your employment. So let's break down each of those elements. First, the language or conduct must be concerning or on the basis of your protected characteristics. And I'll put a list of those characteristics on the screen now. The characteristics are things like your age, race, sex, gender, LGBTQ status, disability status, among many other things. The harasser makes comments or conduct concerning a protected characteristic when the conduct or comments are explicitly linked to your protected characteristics, like saying something racist or ageist or sexist. But the harasser doesn't need to explicitly say anything racist or sexist. If the harasser is targeting you because of your protected characteristics and not targeting anyone else outside of your group, the conduct may still be attributable to your protected characteristics. Second, the language or conduct must be unwelcome. That means that you personally found the words or conduct to be offensive, and that anyone in your position would have also found it offensive. And it also means that you did not solicit or incite the behavior. In other words, you did not start it. The best way for you to show that you found the behavior offensive and did not solicit or incite the behavior is by telling the harasser that you found it offensive and reporting it to HR. Putting your complaint in writing is always best because it creates a record, which we can use as evidence later on. But your memory of the events also counts as evidence. Finally, the language or conduct must be so severe or pervasive that it alters the conditions of your employment. Remember back to Title VII, it has to alter the conditions of your employment. Severe means that it was extreme, like threatening, yelling, or touching. Pervasive means that it happened persistently over a period of time, like little jabs over and over again. And altering your conditions of employment means that the harassment made it difficult for you to do your job, Maybe you had to change where you worked, or how you got to work, or you had to take your lunch earlier, or use different entrances to get to your desk. Now that you know what a hostile work environment looks like, the next question is your employer responsible? Your employer has to be responsible in order for you to bring a lawsuit. Well, employers are responsible for a hostile work environment under two scenarios. First, if an owner, manager, or corporate officer participated in the behavior, the employer is then automatically responsible. But what if it was a coworker or non-managerial staff? Well, under those circumstances, the employer is only liable if it knew or should have known about the harassment and failed to take prompt and adequate corrective action. An employer knows or should know about a hostile work environment if you report it to HR, or if it's so pervasive through other circumstances that the employer just should know. And when an employer fails to take any corrective action, like investigating your complaint or separating you from your harasser or disciplining the harasser, the employer is then liable for the hostile work environment. Now, what do you get if you win your case of a hostile work environment? Well, victims of a hostile work environment can collect their lost wages, emotional distress, attorney's fees, and sometimes punitive damages to punish the employer. If you were fired or you quit because the hostile work environment was so severe, you can collect the amount of salary you would have gotten had you remained in your position. You can also recover compensation for the emotional harm you endured, like humiliation, embarrassment, fear, anxiety, loss of enjoyment in life. And if you prevail on your claim, you can also collect your attorney's fees, which will be substantial if you take your case all the way to trial. Now, I'll make another video about how to calculate these damages, but I'm going to save that for another time because this video is already getting pretty long. Okay, so now you know what a hostile work environment is. It happens when a worker is subjected to language or conduct about their protected characteristics that the worker did not welcome, and that was so severe or pervasive as to alter their conditions of employment. And your employer is responsible for the hostile work environment if a manager or supervisor participated in the behavior, or the company knew or should have known and failed to take prompt and adequate corrective action. If you live in Washington State and you think you were the victim of a hostile work environment, feel free to reach out to my firm. I represent workers in lawsuits against their employers. And share this video with other workers. The more we hold employers accountable for their wrongdoing, the more we protect other workers. That's all for me this week. See you next time.